I am Bill Rochelle, the columnist and editor-at-large for American Bankruptcy Institute. In these weekly videos, I'm always talking about a decision from a federal bankruptcy court or often from federal appellate courts. But today, I'm going to do something I've never done before, and that is, I'm going to report a decision from a state court having to do with bankruptcy. And the court in question is none other than the Arizona Supreme Court, which a couple of weeks ago handed down a very unfortunate decision regarding homestead exemptions. In Arizona, citizens of that state who go bankrupt are not entitled to take so-called federal exemptions. They may only have Arizona state exemptions. And of course, Arizona provides an exemption for homesteads. Included in that homestead exemption is an exemption for a mobile home. That's the word in the statute. It only says that a mobile home is exempted. A case came to the Arizona Supreme Court where the High Court in Arizona was asked to decide whether a recreational vehicle or an RV would qualify as a mobile home. Well, at first blush, Lord knows, an RV, a big old RV that can sleep several people, is certainly mobile. So you'd think, yes, an RV would be a mobile home. But the Arizona Supreme Court said no. RVs, although they are very mobile, are not exempt. The Arizona Supreme Court, in the course of this decision, of course, said that a manufactured home that once was on wheels, maybe it had the wheels removed and it was connected to gas, electricity, sewers and whatnot, would be exempt, although at that point it's certainly less mobile than a mobile home. So curiously, the more mobile form of a mobile home in Arizona is no longer exempt. This is a problem for some people in Arizona because there are probably tens of thousands of folks who live in that state, either part or all of the year, in an RV. But as of the decision a couple of weeks ago, folks like that who file bankruptcy are going to be left homeless because there is no homestead exemption for an RV in Arizona. Like I said, this is an unfortunate decision, and no other court anywhere in the country can do anything about it because the Arizona Supreme Court makes the final authority on Arizona law. However, there is a way out, and that is, I certainly would hope that the Arizona legislature would have a look at this decision and then modify the statute to provide that people who actually live full-time in their RVs will have a homestead exemption. Like I said, I am Bill Rochelle, the columnist and editor-at-large for American Bankruptcy Institute. I shall return same time next week with something interesting from the world of bankruptcy, but I kind of doubt it's going to be as interesting as this decision from Arizona. Thank you and good day.